Thank you very much, Mr. Deputy Speaker. The Finance Bill is an omnibus legislation, and this is a mammoth bill, as has been stated by previous orators, especially Honorable Xavier Duval, Leader of the Opposition. It's a mammoth bill with 84 clauses and 13 schedules. And I have to register our complaint, and very much like what has been stated by Honorable Xavier Duval, I'm yet also to understand why the memorandum was circulated only on the threshold of the debate. Mr. Deputy Speaker, the bill is being introduced against a backdrop of a global economy which is edging towards a recession, against a backdrop of cost of living which will go up with further depreciation of the rupee and high treason on the domestic front. The latest, of course, is the downgrading of Mauritius by Moody's credit ratings. We are hanging by a hair's breadth, a notch above junk status and on the edge of the cliff. As we say, take the IMF prescription, otherwise go the Sri Lankan way. I hope our economy will not be on a free fall. But there's a price, of course, to pay for economic mismanagement. The regime should not get away, and it is responsible for the devastating impact on commercial banks, and through no fault of theirs, and now de facto below investment grades. Beware of disinvestment. Mr. Deputy Speaker, the devils are not in the details, but on the wall of the regime with bold characters. They are, of course, unintended, deliberate, and intended consequences of the legislation. I hardly notice any policy measure, and many clauses deal with administrative tightening measures when there should have been consequential amendments. Some of the clauses, unfortunately, are tailor-made to enable winners like Mr. Lishim to take all. Notwithstanding that his business escaped tight scrutiny, he is now the lord of Champ de Mars, state land, till or if ever he moves to Côte d'Or. Glory to the political war chest of the centrist. Mr. Speaker, with or without those constantly replenish the war chest of the centrist, the countdown has started, and it's game over for Prime Minister. Let me, after these opening remarks, come to specific clauses. The amendment to the Animal Welfare Act. Yes, they make things tidy, and Section 36 of the Animal Welfare tightens penalties, but enforcement remains the crux. In Section 41, after Part 5, new parts are added, namely 5A, to ensure that breeders of animals for competition, pure breed, or leisure have a breeder's permit issued by an officer in charge of the Department of Veterinary Services. But it is easier said than done. Are the breeders registered? Most of them are not, and they have the habits of saying they keep these animals or as pets. Animals cannot be bred in a limited, confined perimeter. It's being done, and there are provisions for offenses. I pray for enforcement. The MSOR certainly remains a real eyesore. And I was told that the Minister of Agro-Industry did make a side visit to Abercrombie, a surprise visit, I was told, and I'm sure he was shocked, appalled, and flabbergasted to take stock of cruelty inflicted upon the dogs. They say that strong dogs were making a meal of weak dogs, and that was the reality. My first prayer, which is yet to be answered, is neutering of stray animals, and a campaign for proper catching should be the last, and as a last resort, disposal of animals. Vicious campaign has been waged against Mauritius, considered by many as a destination of cruelty to animals. I know of tourists, especially from UK, who have adopted stray dogs and become part of the family. Mahatma Gandhi, the apostle of nonviolence, advocated this policy towards animals, protection of the sacred cow. Mr. Deputy Speaker, the Finance Bill does not address the reform required to make the Bank of Mauritius fiercely independent. As I say, no one can ignore all the recommendations of the 2022 IMF Article 4 consultation mission. The Minister has promised that the Bank of Mauritius will no longer be the ATM of government. It will be decoupled from the MIC, and unused funds will be returned to the Bank of Mauritius. The Minister of Finance, in a reply to a PQ asked by Honorable Ramphal, promised redress and highlight the independence of the Bank of Mauritius. The amendment to the Banking Act for approval of a license to the applicant will be void if terms and conditions are not clearly spelled out. As may be determined, is neither here nor there. Uncertainty will open the door for the likes of Ketan Somaya, the Sukon, and the Sobrino. We paid a heavy price by looking at Sobrino in the eyes. King Kong Ketan Somaya, jailed in UK for multi-million fraud. And the banking license to the free operators were issued when the MSM was in power. We say no to shades of grey and yes to transparency. Mr. Speaker, let me now come to the pension scheme and civil service family protection scheme and their intended consequences. Now, I thought I was the one who was targeted, but then I was told that since I make a contribution of 4% of the wages which I'm entitled to, it's going to target those who make a contribution of 2% of their wages. And even then, it's discriminatory. I hope the minister will take corrective measure, because this is not only discriminatory, but it is anti-constitutional. Mr. Speaker, the law may be an ass, or is an ass, but it cannot deprive a citizen of a return on his contribution. I recall that the regime of Sanaru Jagannath wanted to compulsorily acquire the residence of Kishore Diyapal Singh because he was a dissident MP. And if it were not for Sir Satkam Boolell, the then regime would have gone ahead with it. The matter was discussed in the Council of Ministers. If the Honorable Minister wants to review pension, and if the review is part of a balancing act of risk and rewards, at least he has a responsibility to tell the public. Let me come to the pension schedule for year 2023 or 2024. This has been well ventilated that it will be implemented in June 2023. There is a confusion, though. I don't know whether the confusion was deliberately triggered in the light of an article which appeared in a daily. Is it linked to the outcome of the case entered by Petitioner Dial to contest the seat of the Prime Minister in constituency number 8? I hope that they will not find excuses to reschedule full pension payment to those who are 65 years old, those who are 65 years old, and that the scheduled payment is made in due time as promised. Mr. Deputy Speaker, it was, as I said, spelled out loud and clear by Prime Minister and Minister of Finance that monthly pension payment of 13,500 rupees would be effected as from July 2023. With constant depreciation of the rupee exacerbated by downgrading of credit ratings to a notch above junk status, the outcome will be light featherweight pension scheme. And to prepare for a graceful retirement, state employees are bound to contribute to a pension scheme. In Clause 31, there is provision in Section 27DB to increase the contribution from which they would be entitled to from 30,000 to 50,000 rupees, the maximum allowable deduction in respect of contribution made by taxpayer to a personal pension scheme for the provision of a pension for himself. But for God's sake, I expect the minister to come clean and spell out very clearly commitment given in respect of pension or payments which should be effected in July 2023. Mr. Speaker, Deputy Speaker, with an aging workforce, we are already in the doldrum. Contribution for one eligible pensioner will be drawn from a workforce of 2.4 persons. It is a scheme which will run out if fundamentals are not addressed. I hope we will not be an IOU nation. Let me now turn to clauses relating to agricultural sector. Clause 26 is being amended to empower Food Agricultural Research Extension Unit to do what its objectives are. Emphasis on research work in the non-sugar sector. But again, it's like bursting an open door with a butt from the head of a ram. Agricultural sector and agro-industry, I would ask the minister, unfortunately he's not here, where are the findings of the latest report of the opportunities in the non-sugar sector? As to self-sufficiency staple commodities like potatoes, onions, I would say, Mr. Deputy Speaker, it remains a forlorn dream under this government. The Minister of Agriculture of Agro-Industry should define policies to prevent encroachment on prime agricultural land. And there's an urgent call for clear demarcation line on land use and planning. Land under forestry is a bare minimum. Forestry is a good carbon dioxide cleanser, but there's a call for reforestation. And if we have to reach and meet our commitments given by the Minister of Environment on mitigation and adaptation target by 2035. Our biomass framework is yet to be subject of wide discussion with stakeholders, and the price should be indexed on heavy fuel oil. Mr. Deputy Speaker, only the price of bagasse has been determined, but still on the low side. I hope justice will be done to the planters. Clause 39, the Mauritius Agricultural Marketing Act amended. I ask myself, what is the purpose when the Objective Agricultural Marketing Board is an importer and buyer of last resort? There is a call to revisit the objectives of AMB to make it more responsible to consumers, wholesale buyers, and sellers. Let me come to the Mauritius Cane Industry Authority, which is being amended. I'm glad that the Mauritius Cane Industry Authority has spared the sugar syndicate and has not ripped off its membership from the International Sugar Organization. You may recall I made a strong plea during my intervention in the debates on the budget not to disrupt a system which is delivering. As we say, never repair if it's not broken. And there is a sacrosanct relationship, and it gives a marketing leverage to the Mauritius Sugar Syndicate. Clause 26B of the Mauritius Cane Industry Authority in Section 24 to exempt producers and sellers using small tonnage of cane for production of cane juice for direct consumption from requiring the approval of the Minister of Agro-Industry. The ultimate beneficiaries are the miller planters who have a cluster with value addition, and they will use a sizable amount of the cane juice to be processed at their refineries. There will be an impact on the tonnage of sugar production. It's a choice, but the interests of small planters also have to be safeguarded. By deleting V and O, there is no obligation then on big planters to send a specific volume of tonnage of sugarcane to the mill. How big is the small tonnage of sugarcane to be earmarked for cane juice? This is yet to be spelled out, and I expect the Minister to inform the House. Now, I grant you, Minister, it is an administrative burden. There is a niche market to capture, and our sugarcane juice rum, of course, is much sought after. As you say, it toast to the spirit of the planters, but fair and reasonable price to small planters who will send the cane juice to the bottlers. Mr. Deputy Speaker, the Sugar Industry Efficiency Act is inevitable, as the Minister did not even have an iota of oversight on the Sugar Investment Trust, which has become unworthy under this government. Time for amending. The amendments make the Minister the master of the trust, and I expect he will not exercise undue pressure, but will allow the trust to deliver. Oversight, yes, but no stronghold. A vicious campaign was waged to provoke the departure of the CEO of SIT. He was wrongly accused of providing information to the opposition on the financial irregularities in relation to Water Park. He was unfairly accused of providing information to the opposition, and yet he had to put the SIT, and yet, he was the one who started to bring reform to make the SIT more workable and more responsive to the needs of its members. Unfortunately, the board has been operating without the CEO since the end of June, and the SIT has been taken over by one board member, allegedly representative of small planters, and it has a stronghold over the 5 elected members. I hope the Minister acts diligently and do not repeat the mistake made over the appointment of 2 members on the board of the Sugar Syndicate. They are not even representative of the Federation or Association of Sugarcane Planters. The planters who are members of the Federation feel aggrieved over the nomination of 2 non-members on the board of the Sugar Syndicate. The board of the SIT will be newly constituted, and may I remind the Minister, any departure from sound management, that is accountability and transparency, will blow in his face. Today, the SIT is a losing concern, and I expect it to come with a restructured plan to make a U-turn and to be profitable trust and eventually pay dividends. Mr. Deputy Speaker, let me now come to Sugar Insurance Fund, C50A, clause 50B, clause 50C. Now, normally all these amendments are being revised after an actuarial exercise has been carried out, following representation by association of planters. This is the due process. By amending Section 2I of the Sugar Insurance Fund Act, in definition of normal years, by deleting the word 8 crop years and replacing it by 5 crop years, planters stand to lose. The crop is insured on the average of the 3 best years out of 8 years, which give them a better insurable tonnage on average. The Minister needs to find time and interface with the planters community to address the long outstanding issue. Let me now move from cane field to horse racing. The changes to the horse racing related section will further increase the interference of the Gaming Regulatory Authority Board in the matters of horse racing organization. I'm referring to the amendment F and G, which correspond to Section 30 and 31 in the GRA Act. Why does the Gaming Regulatory Board concern itself, and the question has been asked, with horse racing matters when there is a horse racing organizer. Amendment H relating to Section 33, fees payable by the gambling operators to the horse racing organizer. Once again, the board is determined, and the way it's acting, the board is determined on killing an industry that provides a living to so many people. Over 10,000 people live from racing directly or indirectly. Was the horse racing division under the GRA board? And if it is so, and as it is, the horse racing division is under the GRA board, therefore the GRA is acting as judge and party in horse racing matters. There is no clarity on the number of horse racing organizers and what are the criteria for a horse racing organizer to be awarded a license. Has there been a public call to invite those willing to apply for a horse racing organizer license? As we say, there's only one winner, and it's Mr. Lissing. Is there commitment to evaluate the application?
Honorable President, it's not proper to take the name of somebody who's not in the parliament. You wish to wait. I think it's quite fair.
Reading, but
thank you very much.
I'm stating fact. Thank you very much. Now, let me come to laboratories. Why source out other laboratories for blood sampling? The minister will have to tell us. And can the minister provide which countries, the logistic that will be involved, and the cost, the duration to receive the results? What will happen to quantity lab, which carry out those tests? Mr. Deputy Speaker, following the case won by a gentleman, I won't drop the name, HT, regarding the operation of limited payout machines, will he be allowed to operate? Same. I hope so, because he has won his case. The ruling was in his favor, and I expect that he will be allowed to operate. After seeing seals affixed to its gambling machine, the HT Investment Company Limited, as I say, won the case before the Supreme Court. Now, the judgment was pronounced by the senior punitive judge and Judge Benjamin Marie Joseph. Now, but unfortunately, there's only one limited machine operator, namely SMS Parias Limited, and it obtained its license in May 2018. So there's been a court ruling, a ruling that has gone in favor of this gentleman. I hope that justice will be made, and he will be entitled, certainly, to operate the gambling machines. Now, the Gambling Regulatory Authority Act amended the Gambling Regulatory Authority Act, and therefore the horse racing organizer means a public limited company set up with the object of organizing horse races in Mauritius. In Section 2, by deleting the definition of the horse racing organizer and replacing it by the following definition: horse racing organizer means the holder of a horse racing license. The amendment number A, bracket 3, the lottery implies the regulator will regulate promotional lotteries being conducted online via the internet. However, does the promotional lottery amount to internet betting? Is internet betting being allowed? These are relevant questions that need to be answered, and it seems that everything is lopsided in favor of the gentleman whom I mentioned. Mr. Deputy Speaker, till date, we have to remind the House that the GRA issued a tender to appoint a management company to set up the rules governing internet betting activities. Of course, we have to know what is the status of this tender and who was appointed. Let me conclude by referring to the Medical Council Act being amended in relation to registration of those who have graduated or are going to graduate from the University of Mauritius and would be entitled to temporary registration. Now, then they will have full registration. But let me make an appeal to the minister to see to it that there is a differential treatment, and that should be extended or given to Mauritian doctors. And for those foreigners who are here working in hospitals, but who have a full registration, may I appeal to the minister that there should be on a limited registration, as is currently being done in many countries in Ireland and UK. The Pharmacy Act, yes, we welcome the amendment being brought, but there are lessons to be learned and drawn from allocation of contracts. I'm not going to go into the high-perform saga in respect of quality, potency, and price of drugs purchased. In the past, we used to have a manufacturing plant, which used to manufacture drugs. And I'm sure some of us would recall that the drugs manufactured were of poor quality. Forget about bioassay, forget about the relevant equipment which should have been available, forget about samples which should have been assessed elsewhere. But you know, I recall there was an MP who brought a glass of water, purchased one of those drugs, and it was supposed to be a soluble drug, drop it into the glass of water, but it never dissolved. So my appeal to the minister is to take all necessary precautions, to err on the principle of caution. It's all right to bring amendments to appropriate legislation, but at the end of the day, we have to deliver. If we want to be a brand name, and if we want to be a destination of repute, and if ever there is room for export of drugs, we cannot be termed as laggards. Either we are professionally, we bring in those who have the acumen to do the job, because at the end of the day, visibility and tangibility matters. I hope the minister will respond to some of the questions I've put, and I'm sure that the finance bill, though many of the clauses in the bill are for administrative purposes, but there are some issues which have been raised, of fundamental issues, in relation to the right of an individual of a Mauritian born, man or woman, who are equal before the law, but there cannot be treatment which go against this equality. Before the law, we're all equal, and I sincerely hope that in relation to the widows who married under the Family Council law, certainly rights and obligation will be complied with. At the end of the day, we have to make sure that we are all equal. Thank you very much.